Oyez, oyez, oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Morning.
Just set up. Please go ahead.
Good morning, Justice Hennessy. Yesterday, we left off discussing the Crown's failure to adequately consider the past needs of the Superior Anishinaabe. And in that discussion about needs, Your Honor asked a good question about whether payment in 2025 of the amount that ought to have been paid by way of an annuity in 1925, together with an interest rate up to 2025 at a bring forward rate that the Superior Anishinaabe would be satisfied with, would fully compensate the First Nations for the harms caused by the failure to make the payment that should have been made in 1925. I fear that I may have left the court with a misleading impression based on my answer to this question yesterday. And this is because there is an important distinction to be drawn between the Superior Anishinabe's needs and the harms or the losses that flow from the treaty breach. The needs of the Superior Anishinaabe in any year are absolute and unconnected to the amount of net Crown benefits available to be shared in that year. In any regular annuity augmentation, the Crown must consider the needs of the Anishinaabe at that time to determine whether to augment the annuity, and if so, by how much. Needs is one of the factors identified by the Supreme Court. We say that the Crown erred in its exercise of discretion in this instance because it refused to consider the past needs of the Anishinaabe in exercising its discretion over past compensation. On the other hand, the harms suffered by the Superior Anishinaabe because they did not have the benefit of the augmented annuities for the last 175 years stem from the treaty breach. And these are the harms of being deprived of their share of the wealth from the land for so long. As Mr. Bass explained yesterday, we say that the Crown's error with respect to harms is their refusal to I can see that you have a question.
Oh, go ahead.
Is their refusal to consider or account for the actual losses of the Anishinaabe, including by using an appropriate bring forward rate.
Okay, just that last proposition you say, as Mr. Bass explained, we say the Crown errors in respect of that.
In respect of the harms, the error is the failure to consider the loss, the actual loss of the Anishinaabe by not having the benefit of the augmented annuities for so long.
What is the loss?
The loss of investment.
Sorry, maybe I'm, you were making a distinction between when you started needs and losses, and you say in any particular year, the needs are absolute and unconnected to the benefits available to be shared. So let me see if I get that. So unconnected to the benefits to be shared. So if there were zero benefits and there would be there would still be needs.
Correct.
But if there were abundant benefits and they had been shared, there might still be needs.
There might still be needs. Yes,
Okay.
Justice Hennessy.
And so the so those are needs. So then the harms suffered because there was no sharing of a benefit, whether it was a slight benefit or an abundant benefit. Those harms arise from the deprivations flowing from the non-sharing.
That is exactly right, Justice Hennessy.
And I presume your next step is, and the obligation is firstly to fulfill the treaty promise of sharing the wealth if it is available to be shared, or sharing some portion of the wealth that is available to be shared. But there is an additional obligation. Is that where this line of thinking goes?
I guess another way of framing it would be in determining whether there's wealth to be shared and how much of that wealth is appropriate to share. The obligation on the Crown is to consider the needs of the Superior Anishinaabe at that given point in time.
So the exercise of discretion, you say,
requires the Crown to turn its mind to the needs of the Superior Anishinaabe in determining an appropriate share to address or account for part of those needs. There may be needs that remain unmet or outstanding after an honorable augmentation of the annuity, but the Crown must turn to the needs and assess what an appropriate share would be in light of other legitimate polycentric considerations.
right? And my hypothetical, I believe, was that there was a consensus, perhaps, on the amount of benefits, and that the share was appropriate, and that the bring forward rate was appropriate. And my question was, under that scenario, are there still, now I'm forgetting, what is the word I'm looking for? Harms?
Right.
And so I thought you were setting up this morning to say, yes, there could be independent harms, but you say, in fact, that the needs that the needs should be taken into account in the determination of the appropriate share in any particular year.
That is
So in the hypothetical, had the share been appropriate in the minds of the Anishinaabe, would there still be independent harms
right. And
for
this
the breach of the treaty?
And this is where I'd like to be more clear. This is where the distinction between harms and needs matters. If I could take you back to your thought experiment myself, let us just assume that addressing all of the Superior Anishinaabes needs in 1925 would require almost 100% of all of the available wealth of the land to be shared. And then let's assume that the parties do agree that based on legitimate polycentric considerations that the Crowns have explained to the Superior Anishinaabe, the best that the Crown could do under those circumstances is to only pay a fraction of the Superior Anishinaabes needs as part of this augmented annuity. And so then there would remain unmet needs that would still need to be considered when the Crown contemplates annuity increases in later years.
Okay, so just go back to the start of that. You say in this hypothetical 1925, there were benefits, everyone agreed what the benefits were, and the needs, possibly everyone agree, or both parties agree to what the needs are, and they are dramatic. They're they're huge needs. And the Crown explains that because of other demands on the public purse or public policy, that they cannot meet all those needs in any one year, or that particular year in 1925.
Right.
Even though they agree that those needs exist, they cannot meet them. Then you say, what is the next step?
Well, those unmet needs would then remain and would need to be considered by the Crown when it contemplates augmenting the annuity in later years, say when the benefits are greater and there is a surplus, for example, that could account for those outstanding needs that remained unmet in the past.
And that, I believe from the beginning, Mr. Schachter has made that point, that in any particular year, or even in 2025, should the Crown say, yes, we agree that these are the needs, or this is the amount owing, but we have a problem on our side, for whatever reason, paying that amount or transferring that amount or making that exercise of discretion, or exercising our discretion in a way that addresses those needs, that becomes, that amount gets added to a debt, or that amount gets added to a ledger of amounts owing, or that amount, or that amount moves to a new column on the ledger of harms to be addressed. Is that, my worry was that that I wasn't fully comprehending harms as a distinct category of an obligation. And if I follow you, I'm thinking it's not a distinct category. It's what the plaintiffs say would have been the proper exercise of discretion, or would have been the necessary exercise of discretion, but for the Crown's polycentric competing demands. But that the Crown should never get the benefit of those demands in any one year, that those just get added to the future ledger, to the future obligation. Do I understand that position?
I would not agree with the characterization of it becoming a debt owing necessarily, but it remains a relevant consideration for the Crown to turn its mind to at any later date, when it does consider whether it is an appropriate time to augment the annuity, and in determining by how much. Those past unmet needs remain an important, relevant constitutional obligation on the Crown to consider in its future exercise of discretion in any year, in the context of this hypothetical example in 1927, for example. Those unmet needs remain, and so they need to still be addressed as a part of contemplating future annuity augmentations. Whether they automatically become a debt owing depends on the other factors that the Supreme Court of Canada has prescribed, and as discussed earlier, there may be legitimate polycentric considerations.
So, am I correct in concluding that your position is that the Crown's inability, I'm going to use the word inability, to include the Crown's explanation that there are competing demands that arise from polycentric considerations? So I'm going to use the word inability. So am I correct in concluding that you say that the Crown's inability in any one year to meet the full needs of the Anishinaabe creates an additional or ongoing obligation that is cumulative?
That is correct. It is the ongoing nature of the treaty relationship and the covenant chain alliance where either treaty partner may tug on that rope to say our needs still remain unmet. Please consider whether the circumstances and the Crown resource revenues warrant augmenting that annuity to help bring us up to speed.
So in the hypothetical, 1925, there are identified benefits that the parties agree on. There are greater needs than the Crown's, again, I'm going to use the word ability, than the Crown's ability to pay. You say in 1926 or in 1927, the Crown should look back at how they did not meet the needs in 1925.
Right, because those needs have not disappeared.
And that those needs should figure into the factors to be considered in the exercise of discretion in 1927.
That is correct.
So, okay, that's 1925. So now we get to 2025. And the exercise is to calculate what have been called nominal amounts, the benefit, to then the Crown is to exercise its discretion, taking into account many things, including competing demands that arise from their polycentric obligations. You say that, let's say that's, I don't know, somewhere between 50 and 100%, I believe is the argument, that in addition to that, there is a separate category, a cumulative obligation from those years where all the needs were not met.
That is correct. The needs that remain unmet are compounded over the years. And we do.
Accumulated.
Yes.
Okay, I know I have asked this question in ways that I did not ask it earlier, so others will be able to jump in later if they want, but I think I understand where you're going.
Just to maybe make sure that we're completely on the same page, I'd like to wrap up this answer by saying one final thing. So the notion that I'm trying to get across to the court is that attaching an appropriate bring forward rate to past annuity augmentations would fully compensate the Superior Anishinaabe for the harms that have been suffered as a result of the treaty breach. But it would not necessarily, or based on the stage 3 evidence, fully address all of the Superior Anishinaabes outstanding needs and
Current outstanding
needs that will continue to need to be addressed on a go forward basis.
Okay.
And subject to any other questions from the court on that point, I'd like to now turn to another deeply troubling theme in the Crown's reasoning on its consideration of needs. Its attempt to dilute or minimize its treaty obligations by pointing to broader colonial harms and discretionary government funding. Respectfully, this approach is incongruent with the honor of the Crown. As discussed earlier in my submissions yesterday, Canada accepts that the compensation should address intergenerational losses and harms associated with the failure to augment the treaty annuity. But in that same breath, Canada pivots to suggest that these harms, poverty, marginalization, the stark income and wealth gaps, stem from other colonial policies, such as residential schools, the lack of an adequate land base, or barriers to labor force participation. And because of this, we're told that some of the needs of the Superior Anishinaabe have been addressed elsewhere through discretionary spending and government transfers. That position is not only dismissive, it is fundamentally dishonorable. Because what Canada and Ontario are effectively saying is this: yes, we failed to honor the treaty, but we also harmed you in other ways. So we shouldn't be held fully responsible to account for all of your unmet needs here. But a wrongdoer cannot point to its other acts of wrongdoing as a shield from accountability. Had the Crown diligently implemented the augmentation clause, as it was constitutionally obligated to do, the history and trajectory of the Superior Anishinaabe could have looked very different. Based on the knowledge of their communities, we heard from the chiefs who testified at the Stage 3 trial and provided insights into what the Anishinaabe would have done with augmented annuities had they actually received them in a timely manner. They discussed how their communities could have used the increased annuities to help their members and their communities chart a different path, one that aligned with the Anishinaabe vision of Minobimatsuwin, the good life. And just to take one example, I'd like to take you to the testimony of Chief Mishano at the Stage 3 trial. This excerpt is not in our compendium, but my co-counsel will hopefully bring it up for us on the screen. It can be found in the Stage 3 record of the transcripts, volume 14, at page 2328. And here we begin with the question, and moving away from individual members, what are some of the ways that Bigtigong Nishnabeg would have used additional financial resources to assist its members in attaining Minobimatsuwin?
Sorry, is this Chief King?
This is Chief Duncan Mishano.
Thank you. Go ahead.
And Chief Mishano responds, well, I keep thinking again about the business side of things, first of all. We will talk about the other ways in a bit, but I keep thinking about the business side. Could Bigtigong, or Ojibways of the Pic River as they were known there, had access to additional revenues, have developed that fishery on their own to help their people, and not just the single private guys trying to do it, but maybe Bigtigong could have done that. And moving down to page 2330, Chief Mishano considers the broader needs of the community and says, and when you look at the services, if Bigtigong, the community, had access to more revenue, could they then now have started building their own schools, paying their own teachers, building their own healthcare systems? We don't know. We're never going to know because they didn't have access to the resources to be able to do that. And so the question then becomes, had the Crown turned its mind to the needs of its treaty partner from time to time and augmented the annuities as required by the honor of the Crown and the duty of diligent implementation, how might that financial stability and self-determination altered the course of history? Could communities have resisted the imposition of residential schools? Could they have preserved their languages and cultures through their own education systems? Could they have been better equipped to mitigate other systemic harms? As Chief Mishano notes, we don't know. We will never know. And that is the tragedy here. Because that counterfactual world, the world where the treaty promise was honored and respected from the outset, is lost. What we cannot do now is to allow that uncertainty to benefit the Crown. That uncertainty must be resolved in favor of the Anishinaabe, not used as a reason to discount an honorable amount of past compensation. This is consistent with the Supreme Court of Canada's holding in Takuhikin, where the court held that First Nations should not be penalized, where it is impossible to determine the position they would have been in today, but for the Crown's dishonorable conduct. Further, as the First Nations have made clear in the engagement process, it is very difficult to disentangle the harms caused to their community by breaches from the Augmentation Clause from other harms inflicted on them by a colonial and discriminatory government.
Is it hard or impossible to disentangle?
It would be nearly impossible, Justice Hennessy.
Okay.
It is true that compensation here is only for the unpaid annuities, and that annuities aren't the cure to all harms the Anishinaabe suffered. And the Crown can't just pay annuities to make up for dishonorable conduct in other areas. But the Crown also cannot honorably use its failure against the First Nations in other respects to discount its obligations here. The evidence shows that the unmet needs of the superior Anishinaabe persist despite all current government funding. These figures that we present account for every dollar of federal and provincial transfer payments. And what remains, what we're talking about here, is the gap of the remaining unmet needs. The Crown's discretionary spending cannot be used to offset treaty fulfillment. Treaty rights are binding. They are protected by Section 35 of the Constitution. They cannot be substituted by the Crown's generosity or withheld at the Crown's discretion. To allow that would be to reduce a constitutional promise to a political privilege. To conclude, the Crown's narrow focus on present-day needs fails to honor the treaty relationship and the principles underlying it.
Let me catch up for a moment, please. What is your link between, what's the link you're making between Section 35 and this proposition between the distinction between the Crown's generosity or the Crown's non-generosity?
The distinction I'm trying to draw here is that discretionary funding is based on political whim and not a constitutionally binding obligation. So discretionary spending cannot be a substitute for treaty annuity payments.
Do you use the word political whim to possibly debase other demands on the public purse. Like it could, I know there is there has been this example of a recent $200 check sent to everyone in Ontario, but that didn't happen every year for 175 years. So when you use word discretionary spending cannot be based on, I presume you're saying it cannot be based on something bigger than political whim, or are you sticking with that?
It varies depending on the political agenda. I would say it is not guaranteed. It is not certain. Discretionary spending does not give any assurances to the First Nations that this amount of government transfers is something that they could rely on in future years, which is what the treaty annuity payments are required to do. They are mandatory.
And you say they should not be seen as an exercise of generosity, but rather as an exercise, a proper exercise of discretion.
Correct. Neither crown has shown how its exercise of discretion meaningfully grappled with the past needs of the Anishinaabe. And as I've mentioned before, those unmet needs have not disappeared. They have accumulated over generations. The Crown cannot now simply consider the present circumstances of the superior Anishinaabe and call it reconciliation. The honor of the Crown demands more. What we are asking this court to do is not to rewrite history, but to finally reckon with that history and to restore the treaty relationship by taking seriously the needs of those that have gone unmet for generations, and not simply those needs that are visible today. Subject to any further questions from the court, I will now cede the floor to Mr. Gover, who will conclude the balance of the submissions on behalf of the Contingent Interest First Nations.
Thank you.
Thank you.
Just let me finish up, Mr. Gover, before you start. When you're ready, sir.
Thank you very much, Your Honor. I begin by thanking you, Your Honor, for permitting me to participate virtually. I appreciate the accommodation. As a housekeeping matter, I can indicate that I anticipate completing my submissions by the lunch hour, perhaps shortly after the lunch hour. I hope that that will be of assistance to my friends who will be addressing the court this afternoon. Now, I will make submissions on behalf of the Contingent Interest First Nations on three main topics. The first is this: I will address the Crown's reliance on polycentric considerations in setting the amount of past compensation. It will be my submission that this reliance is speculative, improperly invoked in the context of historical redress, and fails to meet the standard of justification required by the honor of the Crown. Second, I will address the Crown's decision to inappropriately tie its exercise of discretion to the Robinson-Huron Treaty settlement. perhaps I'll slow down somewhat before I turn to the third.
Okay, thank you. I appreciate that.
And I appreciate that virtual attendance and submissions can result in an ability to watch the judge's pen, as the saying goes. And
I'm not sure how close your camera is to me, but
it's at some distance, actually, Your Honor.
oh, no, I can see that now. Okay.
Yes.
Well,
When
you
you're-
seem like you're sitting right beside me, so
Well, a privileged position. And the third area that I will address, Your Honor, is the appropriate remedy in this case. And I will submit that it's not to remit the matter to the Crown for reconsideration or another round of perhaps empty negotiations, but for this court to determine the appropriate amount of past compensation itself. And Your Honor, it's with that roadmap in mind that I turn to the first issue, which is the Crown's reliance on polycentric considerations. Now, a core constitutional defect in how Canada and Ontario have exercised their discretion in determining past compensation is their unjustified reliance on so-called polycentric considerations, relying on the needs of others. And here we get into budgetary constraints, social policy trade-offs, inter-Indigenous equity, and fiscal pressures. The two emanations of the Crown say that these are in opposition to their ability to compensate the superior Anishinaabe First Nations. Now, we acknowledge that the Supreme Court in Restool, notably at paragraph 309, a paragraph that I appreciate you've seen several times in the course of submissions, recognized that polycentric considerations, including the needs of other Indigenous and non-Indigenous peoples, may inform the Crown's exercise of discretion. But while the Supreme Court in Restool acknowledged that the Crown's discretion in implementing the augmentation clause is, and I quote, a polycentric and discretionary determination that will inevitably reflect many social, economic, and policy considerations. And Your Honor, the reference there is to Restool at paragraph 294. It is important to note that the court did not contemplate that the Crown would use vague and speculative considerations to hollow out solemn treaty promises. And of course, the honor of the Crown demands much more. What Justice Jamal actually said about polycentric decision-making at paragraph 296, and perhaps I'll call upon Ms. Angelova, if she can, to share screen here, is this. Accordingly, this might take just a moment if you'll bear with me, Your Honor. Here we have paragraph 296. And
thank you.
What Justice Jamal actually said about polycentric consideration in decision-making, I'll begin with the words accordingly, accordingly in exercising its discretion. The Crown will have to engage in complex polycentric decision-making that weighs the solemnity of its obligations to the Anishinaabe and the needs of other Ontarians and Canadians, Indigenous and non-Indigenous alike. This is well within the expertise of the executive branch, but much less within the expertise of courts. The solemnity of its obligations to the Anishinaabe and the needs of other Ontarians and Canadians are all to be weighed in the polycentric considerations. But the Ontario Court of Appeal has revisited this matter in the Chippewas of Nawash case. And here I take you to what is marked as Exhibit B. This is our compendium at tab 9, page 1372. And importantly, the Court of Appeal said in the Chippewas of Nawash case at paragraph 153, the Crown's honor cannot be compromised by interests that are axiomatically opposed to those that the Crown has promised to protect. So what we're
Just
left
going
with,
to that. I'm just going to that.
yes, thank
Sorry,
you.
paragraph 150, 153.
Yes.
Thank you.
Thank you, Your Honor. And where that takes us in my submission is this. Therefore, while the Crown can consider the wider needs of other populations, it cannot compromise its honor by relying on interests that are axiomatically opposed to the promise it made to the Anishinaabe beneficiaries. And that promise, of course, is sharing in the wealth of the land. The Crown's invocation of polycentric considerations in this case is flawed for three reasons. First, the Crown fails to appropriately account for its historic pattern of prioritizing settler economies and resource extraction over its obligations to the superior Anishinaabe. Second, the Crown relies on speculative and vague polycentric considerations without identifying how these considerations were weighed in determining the ultimate quantum of past compensation. So in other words, we have speculation here, and we have an inadequate explanation of how the considerations factored into the quantification of past compensation. And third, the Crown misuses forward-looking economic uncertainty to discount the amount of compensation that would be justly owed and liberally paid for past breaches. And Your Honor, I will elaborate on each of those 3 points that we say are flaws in the Crown's invocation of polycentric considerations, beginning with the Crown's failure to appropriately address the long-standing pattern of prioritizing non-Indigenous interests, what I've termed as the settler economies and resource extraction. Now, throughout the, sorry.
No, go ahead, please.
Oh, thank you. Throughout the engagement and negotiation processes, the First Nations have been clear that to the extent polycentric considerations were relevant to the exercise of the Crown's discretion in augmenting annuities in the past, those decisions have already been made. And they've been made at the expense of the superior Anishinaabe. In virtually every instance, over the past 175 years, the Crown made decisions based on past polycentric considerations that privileged the interests of non-Indigenous populations. And
Mr. Gover, when you say in the past, decisions were made that privileged the settler economies. What kind of decisions are you talking about when we're not talking about the exercise of discretion with respect to annuities?
Well, I'm really talking about the exercise of discretion with respect to annuities, Your Honor. We know that, of course, the annuity was never augmented, that throughout the period, the settler economies were privileged, and we've seen claims of expenses for colonial roads being built, for example, from a very early stage in what was stage three, or part of what was stage three. So beyond that, we can look at the broad sweep of history, and I know we're constrained by the record here, so I don't want to go too far with it. But we know that, in fact, the Superior Anishinaabe were restricted to small reserves instead of the traditional territories that they'd had. We know that there has been intergenerational poverty resulting from it. We heard, and here we do go to the record, we heard what I would describe as troubling testimony, and I think of Elder Goodchild's testimony in this respect about the impacts, not just of failure to augment the annuities, but of the policies of the Crown toward the Superior Anishinaabe. So I don't think I can put it any higher than that, Your Honor. I do think that the failure to augment the annuity speaks for itself when we talk about prioritizing the settler economy. But I think we can also look at the result, and the result goes beyond the failure to augment the annuity. The result is the intergenerational poverty and some of the evidence of Professor Stiglitz, which pointed to the broad income gap and other indicia of well-being and economic sustainability, really. So I hope that answers your question.
It does in part. I wanted to know when you talked about decisions that prioritize settlers, whether you were talking about more than failure to pay annuities. But you say, for instance, or you make a reference, for instance, to colonial roads. And so I wonder, generally, are you saying when you look at the expense category that, for instance, Ontario presented, certainly in the first instance, that those show decisions on how to deal with resource revenue?
I do say that, yes, Your Honor, that there were decisions made that had to do with the settler economy that were at the expense of the Superior Anishinaabe, and money could have been used for other purposes, including fulfilling the treaty promise. We have the dicta of the Supreme Court of Canada really excoriating Crown conduct, referring to an empty shell of a treaty promise, referring to the Crown having lost the moral authority to say, trust us anymore. All of that is the result of policy decisions that the two emanations of the Crown have made over decades, for over a century. And I don't think I can put it any higher than that, but the results are profound, and we've got evidence of them, and they are long lasting and with us today.
Thank you.
Thank you. And to go back to a year we've already talked about, maybe we're tired of speaking about 1925, but if we were to go back 100 years, the Crown collected various revenues from the treaty territory. To my point, though, it did not even consider any augmentations to the annuity beyond the $4 per person level. Instead, the Crown decided to spend all of the revenues that it collected from the territory largely for the benefit of non-Indigenous Ontarians and Canadians. And in exercising its, and here we go with complex polycentric decision-making, the Crown afforded no weight to its obligations to the Anishinaabe and virtually 100% to the needs of others. And it does create the need to think about this uncomfortable question. Can we now be confident that decisions made in 1925 that privileged non-Indigenous interests over those of the Anishinaabe were not made for racist reasons? And 100 years later, of course, we can't go back and revisit those decisions. Instead, the exercise now must be to honorably compensate the Anishinaabe while recognizing that historic practice and without unduly depriving the needs of others. But we must also, in my respectful submission, recognize that those needs of others have been privileged for the past 175 years. In addition, Canada and Ontario rely on their obligations to other Indigenous communities under the rubric of polycentric considerations. Canada determined the amount of past compensation, and this is in Canada's decision, page 30, in our compendium at tab 2, page 35. So Canada decision, page 30, compendium, tab 2, page 35. And there Canada indicates that it determined the amount of past compensation in light of the undisputed fact that there are hundreds of other impoverished First Nations communities that rely on discretionary funding from Canada in meeting their needs. Canada also relies on the 2024 Fall Economic Statement to show that it has invested more than $204 billion in Indigenous priorities since 2015. Again, that's in the Canada decision, page 30 at the compendium, which we have as Exhibit B, tab 2, page 35. Canada also discusses the relative needs of other Indigenous populations. Pardon me, Ontario's decision, this is, also discusses the relative needs of other Indigenous populations as cited in the Gelazo and Jones report. And that's in the Ontario decision at paragraphs 183 to 197. Now, on behalf of the Superior Anishinaabe First Nations, we acknowledge that the needs of other Indigenous groups are real and pressing, but they cannot justify reducing the Crown's obligations to the Superior Anishinaabe First Nations in a determination of what is a just, liberal, and honorable amount of past compensation. The wider needs of other Indigenous populations are the direct result of the Crown's polycentric decisions over the past 175 years that privileged non-Indigenous communities. And as the Contingent Interest First Nations say at paragraph 159 of their factum, this amounts to the Crown relying on its historic wrongful conduct towards others as an excuse for not fully compensating the Superior Anishinaabe for past breaches of the treaty. And we say with respect that by citing the wider needs of other Indigenous communities and pointing to the amount of discretionary funding set aside for Indigenous initiatives, the Crown has sought to discount its obligations to one Indigenous group because it has acted dishonorably towards many others.
I have a question here. Let me see if I can formulate it. On the one hand, you and Ms. Angelova say that the Crown should not try to disentangle the harms created by the non-payment of annuities from the other harms that were created by colonial practices. There is a basket of harms, and those harms are woven together with the results of other colonial practices. But this court's, in determining an amount of past compensation, should look at those harms. So that's one argument. On the other side, or following that, you say, yes, there are great needs in the wider Indigenous community that the Crown should not, do you say, should not privilege over what is owed to the superior Anishinaabe, or do you say that they can't be a basis for a discount to the superior Anishinaabe when one considers the determination under the exercise of discretion? Is there a disconnect there? Is there a non-alignment there?
In my submission, there is not non-alignment. In focusing on the harms, the point that I've tried to pursue is simply that the harms done to others and the need to provide remedies for those harms should not be used by the Crown in either emanation to reduce what is justly owed by way of past compensation to the superior Anishinaabe. In other words, I really hearken back to the principle that a wrongdoer should not be allowed to benefit from its wrongdoing. And that's the essence of the point, is that when we talk about the needs, the harms, the losses, and I know that there is a interrelation between what Ms. Angelova has said and what I've said on these issues. When we talk about these, that some essential points relating to our sense of justice require us to take the claim by the Crowns that when we talk about polycentric considerations, that we must think about what I've characterized as other initiatives of the Crown to provide redress for Indigenous populations, that we take into account that the need for redress has arisen from those harmful colonial and more modern policies that have resulted in the need to spend the over $200 billion that the Crown has adverted to in its written submissions. That's the essence of the point, Your Honor. In my submission, it's a consistent submission with what you heard from Ms. Angelova, and it simply comes back to those notions that we have of what is liberal and what is just in the context of past compensation. And of course, you have our submission that it would be unjust to allow a wrongdoer to point to the results of its harmful conduct and say, but wait, that's a reason why we ought to reduce what would otherwise be just compensation for the Superior Anishinaabe.
Thank you.
Thank you. So you have my point then that the position that the Crowns have taken here is inconsistent with what is required by the honor of the Crown, and it does not advance reconciliation. Now, the Crown, in the case of Canada, also attempts to rely on its legal obligations to other Indigenous peoples. It cites funds recently spent on resolving land claims, on underfunding Indigenous child and family services. This is in the Canada decision, by the way, at page 30, again in the compendium, tab 2 at page 35, and also the violation of Jordan's principles. And here the point is that these decisions flow from mandatory legal obligations that Canada owes to other Indigenous peoples. They're not really optional, in the sense that they cannot be used to discount Canada's obligations to the Superior Anishinaabe First Nations. Canada was in this position as a matter of law and not as a matter of, strictly speaking, policy formulation.
But you would agree that any obligations flowing from law would fit within the rubric of complex polycentric considerations, which I presume includes all monies owing.
I do. I just inject that note about the nature of the obligation in that instance. Now, the second flaw that I have referred to in the Crown's claims of reliance on polycentric considerations is its improper reliance on speculative and vague fiscal constraints in justifying its exercise of discretion. And let me be clear at the outset, the Contingent Interest First Nations do not argue that polycentric considerations are irrelevant to treaty implementation. We recognize that the Supreme Court of Canada in Restule at 181 explicitly stated that the Crown's promise to the Anishinaabe requires the Crown to deal liberally and justly with all her subjects, having regard to the relative wealth and needs of all of the Crown's subjects, signatories and non-signatories alike. And again, that's at Restule at paragraph 181. My point here is that that specific reference was made in the context of regular annuity augmentations. And given the longstanding and egregious nature of the breach, if the Crown does seek to rely on polycentric decision-making and the needs of others in the past, then the Crown must clearly explain and justify how those considerations impact on the compensation. This is my point about the failure in the explanation. The First Nations position was made clear on the record in the engagement session on December 11th, 2024, where the meeting minutes, and here we're in the record at tab 108, page 3900, reflect this. RSTFN's position is that the Crowns cannot retrospectively consider polycentric factors for previous years. However, if the Crowns choose to do so, the Robinson Superior Treaty First Nations demand transparency regarding the specific considerations for each year. And the Crown has failed to explain how they weighed the wider needs of others and factored those polycentric considerations into their determination of past compensation. And that,
Can I jump in here? Can I jump in here? You say that the reference in paragraph 181 was a reference made in the context of regular annual augmentations.
yes,
And you say that in the minutes, I don't have the speaker. I think it was the RST. Is this an RST speaker you're referring to?
yes, it's Mr. Schachter who actually made the point.
Okay, you're saying that in the minutes on December 11th, Mr. Schachter saying, okay, tell us how these polycentric considerations, I'm not sure what it was, impacted every year or what they were. Be specific.
Right.
But is that also within the context of regular augmentations?
In my submission,
that is possible?
in my submission, it well could be, because we're concerned with whether we were concerned throughout that process with whether the Crown had ever turned its mind to augmentation.
Mhm.
And then that takes us to the point, though, that there's no explanation given in any event about how these polycentric considerations factored into any decision making at the time. And you'll hear my submission eventually, shortly, in fact, that this really gives an air of unreality to the assertion that polycentric considerations ever entered into the analysis.
Or is the Crown saying they have complex polycentric considerations to take into account in 2025 that impacts their determination?
Well, it will be for the Crown to elaborate on that, but in my submission, it'd be a difficult submission for the Crown to pursue, that something that was justly owed due to all of the failures identified by the Supreme Court of Canada in the stark language it used in its decision in Restool, that amount ought to be reduced because of current polycentric considerations. That's why we say polycentric considerations are really focused more on future compensation rather than what is justly owed for the past. And that will be my submission, but I don't know if that will be the Crown's submission. Of course, we'll reply to it as appropriate.
So if I understand it, you say the polycentric considerations are considerations that would be taken into account in the regular determination of annuities.
Right.
And that this language from the Supreme Court is not part of an instruction on how to assess past compensation.
That's correct. And nonetheless, the Crown, the court rather, requires the Crown to offer an explanation. And you've heard our submission that there is no transparency here. This ought to be an evidence-based exercise if polycentric considerations really entered into it at all. And we're left instead with what I've characterized as speculative and vague references to fiscal constraints in justifying the exercise of discretion. And in my submission, that's a fair characterization.
Thank you.
Thank you. So, Your Honor, we say with respect, the Crown has failed to explain how they weighed the wider needs of others, and factored these polycentric considerations into their determination for past compensation. And that flies in the face of the direction given in the Restool case, where the Supreme Court of Canada said at paragraph 290, the Crown must explain to the superior plaintiffs and the court how it reached its determination and why. Neither Canada nor Ontario has provided specific, concrete detail about how these polycentric considerations were weighed or what alternatives were foregone. And the result is that there is an air of unreality about the Crown's assertions that polycentric considerations really played a role at all. Now, for example, at paragraph 199 of Ontario's decision, and this is in the compendium, Exhibit B, tab 3, page 401, Ontario refers to its 2024 budget spending and states that it expects to spend $162.4 billion in 2026 to 2027 on healthcare. Here we go. This is paragraph 199. Healthcare, education, and welfare needs of Ontarians in general. And in effect, Ontario argues that these wider societal needs justify a reduced compensation amount for the Superior Anishinaabe, implying that a larger sum would inappropriately disadvantage other groups relying on the public purse for healthcare, education, and welfare needs. But you have my point. Ontario provides no explanation as to how the amount of past compensation would impact its future budgets. And we're left in this position. Both Canada and Ontario make vague references to the broader fiscal and economic context. However, neither Crown identifies, and here we get to my point about failure to explain. Neither Crown explains what specific programs or budgets might be affected. Neither Crown identifies which competing interests were prioritized over the Robinson Superior Treaty obligations. And neither Crown identifies what methodology they use to balance those competing interests. And in my respectful submission, that amounts to a failure to meet the justification standard set out by the Supreme Court of Canada in paragraphs 290 and 308 of the Restool decision.
Well, would you agree that perhaps you're setting the standard a bit high? Let's say the justification or the level of detail that you're expecting would be, well, if we move this payment from 3.6 billion to, or sorry, 1.8, each Crown is looking at their own budget. If we move this payment from 1.8 billion to 2.5, it would have to be taken out of the health budget, or it would have to be taken out of the education budget, or it would have to be taken out of the roads budget or the environment budget? Or would it just have an impact on the global budget that is available to the Crown to meet health, education, roads, and environment?
I would answer your question this way, Your Honor. If one were to put oneself in the position of the executive in making the decision, with the direction from the Supreme Court of Canada that the explanation, there must be an explanation for the Crown's exercise of discretion. Now, I would have thought that in the circumstances, some explanation would be appropriate. We have really none here except what we've taken you to. We're left to speculate. And in my submission, it may be that another avenue would be more borrowing, and the government could explain that that would impact on future ability to borrow. We have a reference to the amount of money that is necessary to service the debt. We understand that. But some explanation would be appropriate. And I come back to the point, this is a treaty partner whom the Crown is dealing with. After the Crown's conduct has been harshly criticized by the highest court in the country, and for the Crown then to fail to offer any proper explanation for how it weighed these polycentric considerations, it is unfortunate, and in my submission, unreasonable, and here results in the need for the court's intervention, because we really don't have any strong idea about the answers to any of the questions that you just posed to me, Your Honor, about how this could have impacted on other aspects of the government's obligations to its residents and citizens. We don't have any of that. So in my submission, there must be some explanation, and here there was none.
Thank you.
And I would go further, Your Honor, and submit that the Crown's bald references to fiscal limitations, which we see in the Ontario decision at paragraph 92, as a means of justifying a lower amount for past compensation, is insufficient because neither Canada nor Ontario have set out concrete limitations or deprivations or repercussions on others that would result from honorable compensation addressing the losses of the needs of the Anishinaabe. And this really is partially an answer to the question that Your Honor just put to me. The Crown, and especially Ontario, have just made vague references to spending in other areas and provincial debt. And we see that in Ontario's explanation letter at paragraphs 199 to 200. I'll just leave you with the reference in the interest of, oh, actually, let me take you to it if I could. This is in the Compendium Exhibit B, tab 3, page 401. And the point here is that this is a vague reference to spending in other areas and provincial debt. You'll see here, Ontario says, Ontario spent $75 billion on healthcare in 2022 to 2023, with spending expected to rise to $89.9 billion by 2026 to 2027. Ontario spent $33.6 billion on the education sector in 2022 to 2023, with spending expected to rise to $39 billion by 2026 to 2027. Post-secondary spending was $7.7 billion in 2022 to 2023, and it is expected to rise to $13 billion by 2026 to 2027. And I'll leave the rest, Your Honor, I'll give you a moment if you'd care to review it rather than read it aloud. But you have my submission that this doesn't offer an explanation about the impact on the ability to provide just compensation to the Superior Anishinaabe. I'll take a moment now if the court thinks it appropriate.
No, thank you. I've been able to review it.
Thank you, Your Honor. So you have my point here that Ontario never actually explains how it considered these figures or specifically how they impact on the amount of compensation that should be paid. And as a result, we are left to guess what these numbers somehow, or some unexplained way, do to reduce the compensation that should be paid. And in my submission, the Crown cannot ignore the obligations imposed by its justificatory threshold that it must face according to the Ristoul decision by simply claiming that its determination was holistic. On the contrary, rather than justifying how the needs of others would be compromised by honorable compensation over the course of the engagement and negotiation process, the Crown has demonstrated the fiscal capacity to make multi-billion-dollar discretionary payments to other segments of the population. And I can be brief on this point because Mr. Schachter has touched on it in his submissions. There are concrete examples that are referenced by the letter sent on behalf of the Superior Anishinaabe First Nations dated January 6, 2025, which you have in the record at tab 50 at pages 3385 to 3386. And to summarize, in its 2024 budget, Ontario allocated approximately $3 billion in one-time per capita payments of a $200 rebate to every taxpayer in the province. This was not a constitutional obligation. It was a discretionary political choice and one that cost more than either Crown has offered to the Superior Anishinaabe First Nations for over 170 years of treaty breach. Similarly, Your Honor, in the case of Canada, on November 21, 2024, the federal government announced the Working Canadians rebate and proposed to spend $250 per capita on 18.7 million Canadians, totaling approximately $4.7 billion as part of a broad cost of living relief measure. And again, this was not grounded in any constitutional obligation, but rather fiscal flexibility exercised for policy reasons.
Is there a reference to that, to the Canada expense in the record?
It is, I believe that will be at tab 50 of the record, and I think it's at pages 3385 to 3386. And I know we've got a breakup coming. I'll confirm that. If I'm wrong, I'll correct that.
But that's a letter, I
Yes.
presume?
Yeah.
Thank you.
Thank you. And of course, in the case of Canada, Canada additionally committed nearly $2 billion for a 2-month goods and services tax holiday from December 14, 2024 to February 15, 2025 as part of the Tax Break for All Canadians Act, Bill C-78. And Your Honor, the point here is not to criticize these measures on their own terms, but rather to emphasize that the Crown cannot credibly argue that fiscal limitations or deprivations to other Canadians prevent it from paying what is constitutionally owed when it has chosen to fund large-scale transfers to its broader constituency, including the non-Indigenous population. And I'll begin if it pleases the court on the third point, which can be briefly introduced, and I know we're due for a break around 11:30. The third point here about the Crown's misuse of polycentric considerations relates to the Crown's misuse of forward-looking risk to offset its obligations owed for past breaches. In our submission, a particularly concerning aspect of the Crown's reliance on polycentric considerations is its invocation of future economic uncertainty as a justification for reducing compensation owed for past constitutional breaches. In our submission, this is a troubling shift. It is using uncertainty today to deny justice owed yesterday, and in fact, tens of thousands of yesterdays before that. In my submission, that is the very definition of dishonorable. Both Canada and Ontario, in their respective decisions, rely on the threat of future U.S. tariffs, specifically a 25% tariff on Canadian goods proposed by the then recently elected Trump administration in the US as a factor they considered in exercising discretion under the Restoule framework. And let us look at how these arguments have been presented. And first of all, with regard to Canada's decision, and this is at page 30, it's in Exhibit B, tab 2, page 35. The 2024 Fall Economic Statement, taken together with significant risks to the Canadian economy posed by the threat by the United States to impose a 25% tariff on Canadian goods, demonstrates the important economic conditions that Canada must consider in its polycentric decision-making. Canada must weigh the solemnity of its treaty obligations to the Superior First Nations and their needs with the needs of other Indigenous peoples and non-Indigenous Canadians, as well as with Canada's broader fiscal and economic context. Now, Ontario, in its decision, at paragraph 203, similarly states this, and this is in the compendium, Exhibit B, tab 3, page 402. Additionally, the Crown is concerned about the uncertain economic future, given the threat of the now President of the United States to impose significant tariffs on imports from Canada. The exercise of Crown discretion under the Restoule factors must take into account this uncertainty in the economic situation affecting all Ontarians and Canadians. Now, Your Honor, these statements appear to form a key part of both Crown's justification for why they chose to limit their compensation to the Superior Anishinaabe First Nations to $1.8 billion each. But we submit that this reasoning is flawed in principle, speculative in substance, and dangerous in effect. Both Canada and Ontario have failed to explain the precise nature of the risk posed by the tariffs, how exactly this economic factor was weighed or modeled in their exercise of discretion, or what quantitative or qualitative impact it had on the determination of the amount offered. So again, we're back to a failure to explain, despite what the Supreme Court of Canada has said in paragraphs 290 and 308 of the original decision. Your Honor, I note,
Would this be a good time for a break?
I was just about to ask if it would be, Your Honor.
All right. Why don't we do that? And we'll take a break then, folks, for 15 minutes.
All right.
This court is sit down for 15 minutes. This court is resumed. Please be seated.
When you're ready, sir.
Thank you, Your Honor. Just before we broke, I had adverted to the Restule decision of paragraph 290, and I remind the court that the words of the Supreme Court of Canada there were that the Crown must, and I quote, explain to the superior plaintiffs and the court how it reached its determination and why, end quote. And the court has my submission that vague allusions to international trade risks without transparency do not meet this standard. But there's a larger danger present here, and that is this. The Crown can always point to some vaguely defined future moment of uncertain economic circumstance, recession fears, commodity price swings, inflation cycles, as a basis to minimize its treaty obligations. Most critically, this argument allows the Crown to benefit from its own prolonged failure to honor the treaty over the past 175 years. It makes a mockery of the duty of diligent implementation. Had the Crown implemented the augmentation clause diligently, updating annuities in good faith as conditions evolved over time, it could not and would not now claim that economic conditions in 2025 justify limiting past augmentations. And to use a really absurd example where we take it to the limit, imagine that in 2025, the Crown had said to their treaty partner, we can't augment your annuity this year, in 1925, 100 years ago. And I promise you, I won't go back there again. But it said in 1925, we can't augment your annuity this year because in 100 years, the American president might threaten our economic sovereignty. Of course, that would be recognized as absurd and inconsistent with the honor of the Crown. It would be highly speculative. But that is the effect of the Crown's position now. We say with respect to allow the Crown to invoke future uncertainty in 2025 to justify undercompensating for past breaches that go back to 1850 is to allow the Crown to profit from its delay, to profit from its failure to diligently implement the treaty, to profit from the very conduct that the Supreme Court of Canada described so pointedly in its decision. Allowing the Crown to resort to such arguments in the guise of polycentric considerations would create a perpetual incentive for the Crown to delay implementing its treaty obligations until it can point to some economic environment that is sufficiently unstable so that it can minimize what it must pay. And the Crown might well say, let's not augment the annuities again for decades. And then once some new future economic uncertainty arises, the Crown could say, okay, we're sorry. We'll compensate you now for our longstanding and egregious breach, but because of the economic uncertainty, the amount of compensation will be less because we have to consider the needs of others. And of course, that would make a mockery of the Crown's honor and transform the obligation to act diligently and justify its decision. It would become a matter of political and financial convenience. So to conclude on this first point relating to the Crown's misuse of polycentric considerations, we respectfully submit that the Crown's reliance on polycentric considerations in this case is vague, speculative, and does not meet the justification burden imposed by the Supreme Court of Canada in Restool. We say that polycentric considerations may guide future treaty implementation, but cannot be used to avoid liberal, just, and honorable past compensation that is owed to achieve historical redress. Now, with that, and subject to any questions on the first topic, I would turn now to the second topic that I addressed today, and that is the Crown's improper reliance on the Robinson-Huron Treaty settlement as a benchmark for determining compensation owed to the Robinson Superior Treaty or the Superior Anishinaabe First Nations. And here, Your Honor, the reference in the Contingent Interest First Nations factum is to paragraphs 173 to 200. I won't take the court there, but provide it for reference. There are two prongs to our argument here, Your Honor, and they are that the Crown's reliance on the Robinson-Huron Treaty settlement creates a reasonable apprehension that the outcome of the engagement process was not open, but was constrained by a predetermined ceiling. And we say that proceeding on the basis of a closed mind in this way is dishonorable. And we submit that guidance can be derived by the court from the reasonable apprehension of bias jurisprudence. I'll come to that. Second, we say that the Crown's reliance on the Robinson-Huron Treaty settlement as a benchmark effectively bound the Superior Anishinaabe to a settlement to which the Superior Anishinaabe did not freely agree. In fact, to which they did not agree at all. So I turn now to the first prong in the argument, and that is the reasonable apprehension that the Crown has approached this with a closed mind. In the aftermath of the Supreme Court of Canada's decision, our clients were deeply concerned that the Crown would treat the $10 billion Robinson-Huron Treaty settlement as a cap on what it would be willing to pay the Superior Anishinaabe for past compensation, despite the Supreme Court of Canada's direction to engage in an honorable, time-bound negotiation. The concern was that this wouldn't be an honorable or meaningful process because the outcome was preordained. The First Nations were worried that the most they could possibly receive would be an equal per capita amount by reference to the Robinson-Huron Treaty settlement. This concern was expressed.
Mr. Gover, can I interrupt you here and ask this question? I raised it, or perhaps Mr. Schachter raised it in his submissions, and that is the per capita lens of the 10 billion is one, and for the purposes of the plaintiff's arguments, I believe an improper way to look at the settlement. And another way would be to look at per capita needs or per capita or not per capita matters. That's one thing. And so then when you say we approach the process concerned that there would be a cap, were you also thinking about the settlement being a per capita amount as opposed to a global amount?
We were concerned with that, Your Honor. And of course, 3 levels of court have said that it is a collective right rather than an individual right. But fundamentally, the Supreme Court of Canada identified 5 factors and invited the parties to consider other factors. And you see that in paragraph 271 of Rastoul, and you see it in subsequent paragraphs as well. And you've heard already that subsumed within the 5 factors are the losses suffered by the Superior Anishinaabe. And these are the impacts when we think about the needs and the losses suffered. These are variable as between the 2 populations with which we're concerned here. They're variable as between the Robinson-Huron Treaty plaintiffs and the Superior Anishinaabe. And to impose a per capita yardstick or benchmark here ignores the Supreme Court of Canada's direction about what is to be considered. It ignores what we say is subsumed within those 5 factors, the losses suffered by the Superior Anishinaabe, and it results in the product of a closed mind, and we say that that in itself is unreasonable and dishonorable.
I have another question which you may get to yourself, and if you have planned to, please leave it. And that is, I was thinking yesterday when Mr. Bass made an argument near the end about the importance of this court setting an interest rate for the contingent interest First Nations portion that would be set aside, and that one of the reasons that he was asking the court to set that rate was so that it wouldn't be determined on possibly a community by community basis sometime in the future, and the risk of that is a risk of inconsistent results. And we generally in our dealings with courts and with legal arguments, we identify that inconsistent results is something to be avoided, if possible, and therefore, when we identify a risk of an inconsistent result, we say that's not necessarily a risk worth taking if there is a way to avoid that. A long way to get to what do you say was the risk that the Crowns took in reaching a settlement with one of the parties, one of the groups of plaintiffs? And do you say that they addressed why and how they took that risk when they settled? That, of course, that there was a risk of an inconsistent result either at trial or in future settlements. I'll leave that with you if you are otherwise addressing it.
I will address it. I'll try addressing it now, and I may come back to it. In the example of the interest rates, of course, we're not dealing with variable inputs to the extent we are when we think about the needs and losses suffered by the 2 different populations. And I respect the point that courts are drawn to, and for good reason, to identical or similar outcomes for identically or similarly situated parties. What is different here, though, is what I've described as the needs and the losses. Now, coming to the question about the Crown and what the Crown motivation was, or the risk faced by the Crown was, to the extent I'm comfortable answering the question, and the Crown will, both Ontario and Canada, of course, may wish to address this in their own submissions, but
I will, of course, ask them.
Thank you. And there was something in it for the Crown to settle with one of the parties and to seek to establish a benchmark. I'm going to get into the legal landscape that obtained then. And of course, it was a far different legal landscape than the one that we now have in the post-Supreme Court of Canada era. And you'll hear my submissions, and I'll make them in about an hour. Well, maybe not an hour, maybe before an hour. But we'll deal with the question of the limitations defenses, latches defenses, Crown immunity defenses, all of those things that it was the Crown's interest to perhaps refer to in the course of negotiation, but would have resulted in some discount in what was ultimately paid by way of settlement. So I hope that answers your question. There was some way of mitigating risk for the Crown, and of course, both Ontario and Canada have the benefit of elaborate risk assessment processes when they determine whether it's appropriate to settle cases. But here they were able to, in our submission, settle at a reasonable amount from the Crown's perspective. It was in the Crown's interest, though, and you'll hear me use the word benchmark again and again, to try to establish a benchmark that would limit what the Superior Anishinaabe could assert. And that's the whole point of the submissions that I'm about to address to you.
And I'm sorry if I suggested that I was asking you to delve into the Crown's mind. It was more when you make your argument that there was a closed mind to the Crown's approach. My question was more in the process, in the bargaining, in the negotiation, was the notion or the concept of risk of inconsistent results part of that discussion?
I'd say it was, in the sense that the converse was certainly raised, and that is the question of parity. And you'll see that in the decision letters, and I'll be taking the court to those in the course of these submissions.
All right, thank you.
Thank you. The concern that the First Nations was expressed early and on the record. This is the concern about the Robinson-Huron Treaty Settlement being a benchmark. It was recorded in correspondence during meetings and clearly communicated to both Canada and Ontario at the outset of the 6-month engagement process. And here we're at the record, tab 93, page 3699, meeting minutes from September 20th, 2024. And it's actually worth taking a moment, Your Honor, to review what was said here. And you'll see that Mr. Schachter raised concerns that the Robinson Superior First Nations did not understand how or why the Huron settlement was relevant to the current engagement process or decision-making to be made. That's very similar to the submissions Mr. Schachter has made to you in the course of the last few days. Mr. Schachter noted that the First Nations were not privy to the Huron settlement process and could not understand how that happened with the Hurons, what happened with the Hurons in their settlement is relevant to the Robinson Superior Treaty. This is Mr. Morrison, who's referred to in the next paragraph, the chief treaty negotiator for Canada, who responded the settlement was considered honorable and that both courts and Justice Morowitz had spoken highly of it. But the details of how the settlement was reached remained confidential. And you'll see that I added that the Huron settlement was referred to as honorable by the court, but judges commonly praise settlements given their positive impact on judicial economy. Point out there are significant differences between the Huron settlement and the current process. And there I got into the process and said, we need to remember that since the Hurons settled, the Supreme Court of Canada rejected any limitations or laches defenses. The Supreme Court of Canada made a clear finding of liability of the Crowns, which previously was being resisted. The Supreme Court of Canada commented on the severe and egregious nature and extent of the breaches and the testing in stage 3 of the various options of the experts as to the wealth to be shared has not yet taken place. Now that it had not yet taken place and now it has, any quantification needs to be taken into account the reality that the Crown's witnesses were not well received and were effectively cross-examined on their theories, and the plaintiff's witnesses fared much better. So I then asked the question rhetorically what we can make of the Huron settlement. So that's the point is, and I'll elaborate on this or return to it at least, it was a different legal landscape that existed at the time of the Huron settlements. And I return to the point, though, that from very early on in the engagement process, our clients specifically requested that the Crown refrain from treating the Robinson-Huron Treaty settlement as a benchmark or comparator for the very same reasons why we object to it today. And yet, even after 6 months of the stage 3 trial, where extensive economic evidence was presented and subject to cross-examination, after a Supreme Court of Canada decision, after 6 months of engagement, strikingly, both Canada and Ontario, despite claiming to consider the matter independently and using vastly different methodologies, somehow arrived at the exact same amount of honorable compensation, and that is $1.8 billion each. In other words, $3.6 billion in total, which is almost exactly the same as the Robinson-Huron Treaty settlement on a per capita basis. Now, one explanation is that it is a truly stunning coincidence, but in my respectful submission, that would be an insult to our collective intelligence. Another reasonable explanation is that from the outset, both Ontario and Canada committed to not providing the Superior Anishinaabe with more than what the Robinson-Huron Treaty plaintiffs received on a per capita basis. The reasonableness of this explanation is further demonstrated by the way the Crown ignored our concerns and relied explicitly on the Robinson-Huron Treaty settlement in their reasoning. And this was clear that both Canada and Ontario proceeded to treat the Robinson-Huron Treaty settlement, finalized in January 2023, as a relevant and indeed sensible consideration. Both Canada and Ontario explicitly treat the $10 billion Robinson-Huron Treaty settlement as a benchmark to validate the exercise of discretion of $3.6 billion in total in this case, because it is roughly equivalent per capita. So the Crown here ignored the First Nations objections and proceeded to rely on the Robinson-Huron Treaty settlement despite the objection placed on the record very early on in the engagement process. And I take you here, Your Honor, to page 36 of Canada's decision, which is in our compendium, Exhibit B, tab 2, page 41. And here we've highlighted the salient portion. In this regard, Canada notes that the current population of the Superior First Nations is roughly 37% of the population of the Robinson-Huron Treaty First Nations, letter 21, page 9. Canada's determination of compensation matched by Ontario is 36% of the amount paid to the Robinson-Huron Treaty First Nations. Ontario's decision similarly notes that as of July 2024, the Robinson Superior First Nation population was 38.1% of the Robinson-Huron Treaty First Nation population. And we have that at paragraph 249, which is at page 69 of the compendium. And here we have it on this page with the benefit of a shared screen, Your Honor, reflecting Ontario's decision and the reference to the 38.1% of the Robinson-Huron First Nation population. Ontario also explicitly takes the position that a substantial difference between the per capita amount paid to the Robinson-Huron First Nation and that to be paid to the Robinson Superior First Nations after taking into account the risk factors as they relate to the Robinson Superior First Nations would not advance reconciliation. And Your Honor, Ontario takes that position. It's coming up now at paragraph 240 of its decision, page 67 of the compendium. May not be.
I may have missed your point.
Of the letter. Pardon me, Your Honor.
Mr. Gover, I may have missed your point immediately before you directed me to paragraph 240. Did you say Canada made that argument that to go outside the benchmark would not advance reconciliation?
That was Ontario took that position at page 240.
Thank you.
Paragraph 240.
Yes.
Paragraph 240. I've got it. Thank you.
It is. Thank you. And so our submission then is that this statement clearly demonstrates Ontario's unwillingness to even consider paying the Superior Anishinaabe anything over and above the per capita equivalent of the Robinson-Huron Treaty settlement. Again, we say the product of a closed mind. And
my question is to you and others from the plaintiff's team, did anyone do this calculation for the by tracing the offers? So has this calculation of percentage comparison with the RHT been done with the other offers made by Ontario and Canada? The earlier ones?
in December, I might consult with others and respond to that afterwards. I don't recall that exercise being engaged in. I do recall that, of course, when we got the explanation letters on January 27th, that they did address this issue of the per capita amounts and but if I may, I'll come back to that after the lunch break, Your Honor.
All right. And then my second question on this is, and I know this answer from earlier submissions, but at any point in the engagement process, were these two percentage comparisons made? Was the population percentage ever set out by either of the crowns? And therefore, how that would translate if one were seeking parity on the basis of per capita payment, what the per capita payment was?
Certainly, there was discussion about the difference in population. Again, I'll come back to this and correct myself if I am wrong in saying this. I don't recall discussion in the room about how that would impact on payment per person, but I may be wrong on that and would appreciate a chance.
Thank you.
My colleagues. Thank you.
Thank you. And also, I am not aware of who was always in the room during those meetings, but go ahead.
Understood, and thank you, Your Honor. Now, while Ontario and Canada both assert, and I quote from Ontario's factum here at paragraph 151, that the $3.6 billion was not a preordained result or a ceiling, and that the minister did not effectively tie the Robinson Superior First Nations to the Robinson-Huron Treaty settlement in a linear manner. The evidence suggests otherwise. And in fact, I go further and say common sense suggests otherwise too. At paragraph 108 of its factum, Canada states that its determination was based on the same methodology it developed for the stage 3 trial in January 2023 before the Robinson-Huron Treaty settlement was finalized. But we question that.
Sorry, are you referring to Canada or Ontario?
I'm now referring to Canada's factum, paragraph 108.
Oh, Canada's factum. Thank you.
Thank you. And we suggest that there's reason to question what Canada says in paragraph 108. As you will recall, the stage 3 trial was scheduled to begin on January 16, 2023, and it was adjourned for just 4 days, 4 days earlier on January 12th, for the very reason that meaningful, fruitful settlement negotiations were taking place between the Robinson-Huron Treaty plaintiffs and Canada. On January 30th, 2 weeks later, the Robinson-Huron Treaty plaintiffs asked the court to adjourn the trial as it related to the Robinson-Huron Treaty plaintiffs indefinitely, pending the execution of a settlement agreement that was agreed to in principle. The timing of these events strongly suggests that Canada was simultaneously developing its methodology for both the stage 3 trial as it pertained to the Superior Anishinaabe and settlement talks with the Robinson-Huron Treaty First Nations. And this raises in our submission a critical question. Was there a reasonable apprehension that the Crown entered into the engagement process with the Superior Anishinaabe with a predetermined amount of past compensation in mind based on the Crown's $10 billion settlement with the Robinson-Huron Treaty plaintiffs? In our factum, we draw the analogy to the reasonable apprehension of bias jurisprudence. And of course, the well-known test is whether a reasonable person properly informed and viewing the matter realistically and practically would conclude that the decision maker could not decide the case fairly. And just as a court decision or administrative tribunal decision cannot stand if a reasonable person would conclude that the decision maker was biased, so too the exercise of the Crown's discretion cannot be honorable if a reasonable person would conclude that it was not fairly arrived at, that it was the product of a closed mind. It is not the existence of actual bias that matters. It is, of course, as we well know from the jurisprudence, the appearance of it. And that doctrine applies just as forcefully to the exercise of Crown discretion where constitutional obligations are engaged. As the Supreme Court of Canada recently reaffirmed in Takuhikan at paragraph 186, the honor of the Crown has long required that the Crown act in a way, and I quote now, as to avoid even the appearance of sharp dealing. At paragraph 163 of its factum, Ontario states, and I quote again, in no circumstances can a party allege that a judge or other decision maker was biased based on pure speculation that the judge or decision maker may have favored a particular outcome prior to the conclusions of the proceeding. Ontario cites no authority for that sweeping proposition. And of course, there is a presumption of impartiality applying to judges that has no application to Ontario, which can hardly be described as a neutral decision maker. In fact, there are binding authorities to the contrary, namely that even the mere appearance of bias or a closed mind in the decision maker is enough to set the decision aside. And here I simply provide a reference to a recent Court of Appeal decision, Your Honor. It would be to the King and Cowan 2022 ONCA 432 at paragraph 31.
And is Cowan C-O-W-A-N?
It's C-O-W-A-N, yes, Your Honor.
Thank you.
If Ontario's point is that bias cannot arise from speculation, that is uncontentious, but it's irrelevant in this case. Here, the concern about the Robinson-Huron Treaty settlement acting as a de facto cap on the amount of compensation for the Superior Anishinaabe goes well beyond what Ontario would describe as pure speculation. We have it in their factum, we have it in their conduct. Moreover, Ontario's justification for relying on the Robinson-Huron Treaty settlement is internally inconsistent. On one hand, Ontario claims that the Robinson-Huron Treaty settlement was not determinative, but on the other hand, Ontario's decision letter repeatedly refers to the need for parity on a per capita basis. There is also the striking fact that after everything that transpired between January 2023 and January 2025, Canada and Ontario both landed on the exact same compensation figure of $1.8 billion each, both repeatedly emphasizing that this determination is consistent with the per capita amount received by the Robinson-Huron Treaty First Nations.
I'm wondering if, and I may have raised this before, I'm wondering if the bias characterization that you make can also be described as or fit within jurisprudence of fettered discretion, or if that makes a difference.
Your Honor, in my submission, it can fit within the jurisprudence relating to fettered discretion. And it's interesting, there was discussion about the Crown's discretion being fettered. The Supreme Court of Canada makes it clear in Rastool that it is not an unfettered discretion, that the discretion is informed by the honor of the Crown, by the duty of diligent implementation. Early on in the engagement process, though, Ontario in particular took the position that it could not engage in discussions about, and I'll actually may come to this a bit more in submissions, could not engage in discussions about meaning to be given to the 5 factors identified by the Supreme Court of Canada, because that could fetter the Crown's discretion. And that was an unfortunate position to take, because, of course, we could have had a much more meaningful engagement process had we had some better idea about how the Crown would view those factors. So the question of fettering discretion, I think easily translates into the submissions I'm making now about the closed mind. We're dealing with the result, and we say the result, whether it was due to fettering of discretion or whether it was the result of a closed mind, a reasonable apprehension, at least of a closed mind, that the outcome is the same. So in our submission, the same applies no matter which of those 2 lenses you look at this issue with. Now, this happened, of course, despite the early indication from the 12 First Nations, Mr. Schachter speaking for his clients and I speaking for our clients, about a reliance on the Robinson-Huron Treaty settlement. And you have our point that this could very well lead a reasonable person to conclude that the Crown's exercise of discretion was effectively tied to the Robinson-Huron Treaty settlement, and that the justifications were reverse engineered accordingly. We say that for this reason alone, the engagement process and its result were not honorable. Now, the second prong of this argument has to do with the Crown's actions in binding the Robinson Superior First Nations, or the Superior Anishinaabe, to an agreement they did not make. We say that's inconsistent with the honor of the Crown. Ontario submits at paragraph 16 of its decision that it is just, honorable, and fair to treat the Robinson Superior Treaty First Nations in a broadly comparable manner to the Robinson-Huron Treaty First Nations. Ontario further argues that the Robinson-Huron Treaty settlement is, in and of itself, honorable on its face, and that the honor of the Crown required it to consider the Crown's relationship with both groups to ensure consistent treatment. And the reference there, Your Honor, is to the Ontario decision at paragraphs 243 and 245 at page 68. You'll find it in Exhibit B, our compendium, at tab 2, page 415. This position taken by Ontario completely disregards what actually made the Robinson-Huron Treaty settlement honorable on its face. And it was not the amount of compensation, but the fact that the settlement was the product of mutual agreement. The Robinson-Huron Treaty First Nations entered into that settlement freely and willingly. They had full agency in the negotiations. They were well represented and they consented to the outcome. But the Superior Anishinaabe First Nations were in a very different position. They were not at the table. They were not parties to the Robinson-Huron Treaty negotiations. They were not involved in crafting the settlement terms. They did not consent to any of it. Yet Ontario and Canada both use that very settlement, reached in a different context, under different facts, with different First Nations, as a benchmark to determine what they were prepared to offer to the Superior Anishinaabe First Nations, despite express objections from the Superior Anishinaabe leadership and repeated requests not to do so. Based on Canada's and Ontario's own explanations, they considered it improper to provide compensation to the Superior Anishinaabe that would exceed the per capita amount provided in the Robinson-Huron Treaty settlement. That means that the Robinson-Huron Treaty settlement amounted to a ceiling to the compensation available to the Superior Anishinaabe. And it is for this reason that we say Crown's approach, in essence, bound our clients to the Robinson-Huron Treaty settlement. The end result is as if the Superior Anishinaabe signed on to the Robinson-Huron Treaty settlement for the same amount of compensation per person. The fundamental unfairness of this approach is clear. It is inconsistent with the honor of the Crown to bind one group of treaty partners to the outcome of a confidential process to which they were not privy, and to treat that outcome as if it were a reasonable ceiling for determining their own compensation. And here, I must add that this result is particularly troubling to the First Nations that we represent, the Contingent Interest First Nations, because as you will recall, our clients all maintain that they were not actually parties to the Robinson Superior Treaty because they never signed it in 1850 and have not adhered to it subsequently. Nonetheless, for decades, the Crown has told the Contingent Interest First Nations that they are in fact parties to the treaty, and now the Crown is trying to bind them to yet another agreement that they did not sign and to which they did not agree. And
Thank you.
Your Honor, I note the time. I'm about to move to
How are we doing?
a slightly different area within the same topic, but I do note the time.
Thank you. Then we'll take the break and let me know, please, Mr. Gover, for the benefit of your friends, of course, how much time you think you need following lunch.
I estimate that I need roughly 45 minutes after lunch.
Thank you. Right. Should we return? I see that it's 20 to 1. Should we return at 2:15? Would that suit your afternoons? All right. Ms. Evans is on.
This can be done off the record, but I wonder if we might continue this discussion about timing and who's going next.
All right. So we're off the record. We'll break now. Go ahead.
Thank you.
Good idea.